Hello, everyone, and welcome to the next session, which is Conflicting Visions, with our conference of Conflicting Visions of Alaska History. And we've got conflicts over Alaska Native sovereignty is our next session, and we've got two speakers on our session. Will Schneider, a professor emeritus from the University of Alaska Fairbanks, a board member and former president of the Alaska Historical Society. He will speak for about 30 minutes, and then we will hold off on questions and then go to Steve Haycox, also emeritus professor of history from the University of Alaska Anchorage. And Joe, could you hand me the remote there? And if we get some feedback in our room here, I will be adjusting this. I'm Judy Bittner. I'm the Alaska State Historic Preservation Officer and also a member of the Cook Inlet Historical Society, one of the co-hosts here for this conference. And I think we will go ahead and dive right in, and I'm going to switch chairs with Bill Schneider, who will be speaking on the struggle for recognition of sovereignty and the federal government's responsibility to Alaska Natives. And this paper explores the cultural divide and suggests some reasons why it exists. And so I would like to switch chairs, and because we've got some of the Historical Society folks here in here, so we will be doing a switching of chairs. Okay.
Thank you. Thank you, Judy. We're ready to go. So the paper idea that I'm going to present today developed out of the curriculum guide that Mike Hoffield and the Historical Society produced for the ANCSA at 1971 guide. And we came up with a series of questions that students might have. And so the idea was, what about sovereignty and the federal trust responsibility? And so what I attempted to do was write a general overview paper about that concept. Then out of that, what I thought I would do today is kind of give a 30,000-foot view down on the issue. And of course, there won't be much detail in what I say, but there'll be some overall trends. And one of the things that I discovered in doing this was that there was a pretty interesting connection between the cultural differences of the white settler population that came to Alaska and the Alaska Native population and their adaptation to the land and how they viewed the issues of sovereignty and the federal trust responsibility. So the paper is chronological. I've taken on the whole banana from early years to the middle years to statehood, land claims, and ANILCA. So it'll be a pretty quick run through. Starting then with the early history, beginning with the United States taking over responsibility for Alaska. In 1867, the government recognized a responsibility to Alaska Natives, that there was a government-to-government relationship with Alaska Natives. This meant that Natives had certain rights, not clearly defined at that point in time, but that they did exist and that they were recognized legally. And so the background to this is that this was a period in which shortly after that, 1867, there was a big influx of settler population, largely because of the gold rush. And so there was question about the land and who had rights to fishing and hunting. And we began to get issues about depletion of game in certain areas.
Will, I just have a problem. I'm hearing that we're getting a lot of feedback, problems.
Are we,
Ask Cody if there's.
Cody, are we experiencing feedback issues?
I'm not hearing it myself, but let me do some adjusting here and maybe I can figure it out.
I'm getting a text.
Oh, you
There's
are.
some feedback issues. This is great.
Shall I continue or shall I?
Yeah, why don't you go ahead and continue?
Yeah.
Cody,
In-
we might have to go to earphones for you.
Okay.
Okay, all right.
So in turn, the federal government recognized that it had a responsibility to Alaska Natives. And this was based largely on an earlier ruling from the continental United States in 1831, Chief Justice John Marshall, who recognized Aboriginal title. And it was defined in terms of a wardship relationship and later became more refined by Felix Cohen and others in a later period. But in the earlier years, it was defined in terms of wardship, a benevolent overlord type relationship of responsibility. So these two basic principles of there was sovereignty that was recognized, and there was a federal trust responsibility to Alaska Natives in some form, and that evolved through time. In the early years of the American period, the government and the settler population in general maintained that the best course of action for Alaska Natives was to become like settlers, to work towards taking on settlement customs, beliefs, and way of life, that this would help them and help the settlers to a better adjustment to the life in Alaska. We recognize this now as the settlers asking that the natives take on an agrarian mode of adaptation. We recognize it as assimilationist and paternalistic, but at the time it was viewed as in their best interest. At the same time, there was this underlying legal recognition of rights, and there was court cases and actions that would promote this in terms of the law, so that there was this tension that exists in the early years. So to summarize, the government maintained that through policy and law, that the best course for Alaska Natives was to become like settlers, that the government recognized that there are Native rights, yet undefined, but nevertheless existing. And finally, that the government has a legal responsibility to Alaska Natives to, in some form of wardship or caring for them or accounting for them. So then the middle years, and the middle years I'm defining as beginning with the 1936 Indian Reorganization Act application to Alaska. So during this period, there was a broad-based federal government program to provide local government to villages, to provide some form of economic assistance in terms of programming. But most controversial at this time was the establishment of reservations, a reservation system that came to include not only the land, but in some cases, the waters that surrounded the actual land. And this created particular problems. When the Secretary of the Interior would establish these areas or attempt to establish these areas, the settler population found this an infringement upon their rights, particularly the fishing industry, the canneries, individuals who had investment in fishing in the areas. And so this created a tremendous tension between the native population and the settler population, even though this was a policy of the Secretary of the Interior. At the same time, there was several rulings that established that natives could make claims on land that they had possessed, as well as land that they currently resided on. And I'm referring basically to the Santa Fe Railroad case and to Council Marigold's testimony and position on the Secretary of the Interior's rights to take action. So politicians like Ernest Greening chafed at, and he was an outspoken critic of reservations because he saw them as unjustified extensions of the Secretary of the Interior's role. And he thought it was, in a sense, a form of reverse discrimination. He wasn't alone in these attitudes. He had, as we know, been a champion of equality under the law, and numerous times in his career, he had fought for restaurants and other establishments to give equal treatment to natives. So equality was basic to his blood, to his way of looking, and the reservations he saw as something that if it went against that. That isn't to say that he didn't support land claims, but he had serious questions about reservations as such. So the goal of the government during this middle period was a wish, and was the wish of many non-native Alaskans, was an orderly extinguishment of native claims through the Native Claims Act and later through the Indian Native Commission, Native Claims Commission. So when we look at this middle period that I've summarized all too quickly, we see that the Alaska Reorganization Act reservation policy created the seeds of discontent and antagonism through the settlers. And this was particularly the case with the water issues. We see a movement towards settling native claims through the Claims Commission. And I was amazed when I did some of this research to see the number of communities, and even at the territorial level, the movement towards the Claims Commission, using the Claims Commission as the avenue for settling native land claims early on, quite early on during this middle period. So moving on to statehood, the framers of the Alaska State Constitution established the common use provisions of the Constitution. And this was a way to ensure equal opportunity for access to the natural resources of the state that would become the state. And while this was a guiding principle, and it's something that we can see as the positive attributes of it, it had some very strong negative impact. In practice, this meant there could be no native or rural Alaskan preference to subsistence resources, even in times of shortage. And this was something that at the time, I'm sure that they weren't concerned about or thinking about, but it came back to haunt us in the post-ANCSA period. It's innocuous in its beginning, but it had serious implications down the line. In the Statehood Act itself, there were two conflicting statutes. One of them empowered the state to make land selections. The other cautioned the state against making any selections or leasing any land that might impinge on native land that they might be claiming. So we have this apparent contradiction that created an issue. And also at the time statehood was passed, shortly thereafter, the state began to make selections and began to lease land. And the native community began to make a shift in their approach. They began to use the actual tools of the Western legal system to make their claim. And probably the most interesting example of this is Willie Hensley's famous paper, The Primary Issue, I'm quoting, the primary issue, what rights to land have Alaska Natives? And in that, he, under the tutelage of Judge Rabinowitz, who was his teacher at the time, makes the native land claim statement based on Western law. And this became incredibly important throughout the Native community. It was passed out to everyone to look at. And as we went through the guide listings, we see many, many references to it. So it's one of those primary documents that stuck. At the same time, in the mid-60s, Secretary of the Interior Stuart Udall instituted what we now know as the land freeze. And this meant that the state could no longer select land until Alaska Native land claims were settled. And so this put a tremendous pressure on settling land claims. As land claims legislation progressed, President Nixon called for a change in the federal policy towards treatment of all natives, Alaska Natives and others. And it was a change from termination to self-determination. And shortly before the actual passage, December 18, 1971, signing, of ANCSA, Congress passed Concurrent Resolution 26, in which it changed its policy from termination to self-determination for natives. And so these were major federal actions, a change in the federal trust responsibility and attitude about treatment of Native people. So to summarize the statehood period that I've just discussed, the common use provisions of the state constitution planted the seeds for some major issues that would develop. The Alaska Statehood Act had the conflicting statutes, which again created an immediate problem once they began to select land. And we had the native response and the land freeze by the Secretary of the Interior. So moving on to ANCSA itself, ANCSA was passed in 1971, an act that would in many ways reflect a change in policy as witnessed in Native for-profit corporations, a large land settlement, and final legislative settlement of land claims. In order to accomplish the latter, that is the actual land passage, there had to be extinguishment of Aboriginal title and Aboriginal hunting and fishing rights. This would clear the way so that there wouldn't be future claims, and so that the state and the federal government and even the Native corporations would have an easier access to make decisions about the land and to move ahead with development or activities on the land. And this became very important. But the implication is that native land, native-owned land, would be treated just like any other private land holding in Alaska, which meant that hunting and fishing rights would come under the state fish and game regulations until ANILCA was passed, and then we got into more a dual system. So moving on to ANILCA in 1980, 9 years after ANCSA was passed, Congress passed the Alaska National Interest Lands Conservation Act. And in Title VIII of that act, it established a subsistence preference on federal lands. And basically this meant that rural Alaskans had a subsistence preference on federal lands. This created a point of contention because it conflicted with the common use provisions of the state constitution. And again, it was the question of, can any particular group of people, i.e. rural Alaskans, be given a form of preferential treatment? And the state could not do this. They tried, and there was even ballot initiative action, but in the end, the state, through court cases, it was found that the state could not comply. And this has created a serious problem in terms of how to manage a dual system of management of fish and game. This is true even though the needs of rural Alaskans are really quite different than urban Alaskans. Rural Alaskans who are dependent upon a subsistence way of life. And so I think what we see is a conflicting vision between rural Alaskans and urban Alaskans in terms of, as it relates to subsistence and living off the land. So while native sovereignty has been seriously curtailed by ANCSA legislation, there remains areas of village life where natives are able to maintain a degree of effectiveness in controlling their own affairs. These include areas such as village justice, such as child welfare cases. Some tribes have begun to work in the area of medical services delivery. And more recently, there has been a successful initiative to support Native K through 12 education. So it's interesting that the whole area of sovereignty has, you could say, devolved to a village-based, negotiated, service-oriented thing, but without territorial land reach, and most particularly in the area of subsistence remains an issue. So in the way of conclusion, am I doing okay on time? In the way of conclusion, the early settlers saw the land as unsettled and available. They came with a legal system based on individual legal rights to claim and own land. Most showed little recognition of native rights, nor an understanding of the different way of living, where tribal patterns of affiliation created social ties that linked individuals in a network of kin with recognized land rights and responsibilities. Different from settlers' concepts, which were based on an agrarian settlement and single-family homesteads, and also based on the expectation of settlers that when they came to Alaska, since it was part of the United States, that access to land and access to the resources as citizens that they were entitled to. In a testimony, in the opinion of Ralph Rivers, Territorial Attorney General, or during that middle period that I described, he starts his testimony to the Secretary of the Interior with a description that settlers had come to expect their rights in Alaska, and we can see how this certainly would have been the case. Politicians like Greening could never completely reconcile native sovereignty with equality under the law. Instead of embracing both as coexisting values and rights, he was reluctant to recognize both as possible and desirable. He sought extinguishment of native claims through an orderly process. This was emblematic of others for much of our history who were eager to settle native land claims and get on with equal treatment of all citizens under the law. This attitude is exemplified in the common use provisions that I have talked so much about. The collision of cultures came to a head after statehood, when the new state began to select land to own and to lease, land that was important to natives. Then the native population, the native community, used the tools of the Western legal system to legally demonstrate and promote their claims. But also, in testimonies before settlement, natives stated that the land was key to control of their destiny, that they saw it as key to control of their destiny, a base that had always supported them. Many saw that base as a way to establish economic development and village projects to alleviate poverty where it existed, while based in the tradition that told them that the quote, the land would provide, end of quote. The settlement they sought to achieve was one that encompassed economic opportunities and a financial base to develop. In testimony, they explained that this was not a break from tradition, but instead, the subsistence tradition had always supported them through good times and bad times, and that this was what they saw as their avenue for the future, quite different than the experiences of settlers who came from their own traditions, but not traditions in Alaska that went back to close identification with specific large territories of land that as kin they had used effectively and had common use rights to manage and use. So today, most Alaskans have no understanding of Native sovereignty and the federal trust responsibility, but most know about the success of the Native corporations. This is understandable because the corporations have made an important impact in the state and in the nation. And we can see that economic impact, and it's talked about amongst the settler population. The corporate structure that anchors ANCSA's economic settlement represented a tactical break from Native tradition. The corporate structure has brought rewards to Native shareholders. It has also raised new challenges, such as questions about who qualifies as a shareholder. How does being a shareholder equate with being a member of a Native cultural group? How do people sort out identity as shareholder and identity and their Native identity? And this is a subject that people like Megan Sullivan have been writing about within the Native community. Today, Native people are using the threads of sovereignty that still exist to address their village-based needs in the changing climate of sovereignty and their relationship with the state and the federal government. And this is something I think Steve is going to pick up on here. Steve Haycox cautions us, and this is something that I think we all need to struggle with continually, and I quote, "The role of the historian should be to caution against easily condemning historic figures for judgments that don't fit notions of justice and equity of a later age," end of quote. The issues of sovereignty and administration of the federal trust provide a sobering record to test the ways that we understand the actions of the past within the context of their time. Thank you.
Seems like Steve is having a little bit of an echo issue. Um, uh, Steve, if you are able to mute your speakers and unmute your microphone, we might have a winning combination.
Okay, I'm not getting any echo from what you just said, but I think my mic is providing some feedback there somehow. Feedback goes away.
Yeah, that feedback loop is persisting.
Yeah.
Could Steve try headphones? Could you try your headphones, Steve?
Oh, okay. You got. Oh, no. Okay.
Yeah, Steve, do you want to try your headphones one more time, just while you're speaking, see if it helps at all?
Okay.
Steve, do you still have those headphones handy? We could try those.
Headphones.
Still having that echo.
Very bad.
I wonder if, Steve, if you wouldn't mind just closing out of your internet browser entirely and maybe starting from scratch, and maybe Judy has some questions for Will while that happens.
Sure. I'll give that a try.
Okay. Do we have any questions from the audience for Will on that?
I'll ask one if you want.
Yeah, go ahead.
I don't know if you can hear me. This is David Ramser in the room. Will, I understand there's a sort of a school of thought that some people in the Native community feel like they gave away too much in the Claims Settlement Act. If that's true, what is the argument for what else they could have achieved or gotten?
Why don't you just roll down here?
Yeah. What makes it complicated is the timing of land claims. Oil had been had been found on the North Slope. There was tremendous pressure to get at the oil, to get a settlement, to clear the way for settlement. And I think that the general impression, and I can't speak for the Native community, but I think the general impression was that this was an opportune time to get the best possible settlement. The corporate solution that came out of that was a very complicated development that we've been researching, and apparently there was some strong support amongst Native leaders and AFN, Don Wright and others, to have a corporate solution. Mary Nordale, who worked for Senator Bartlett, claims that she was influential in supporting and suggesting the idea of a corporate solution. But there are other testimonies too. So this was in the air. And so the corporate solution, which we may view now as a very radical break, was something that did have support within some parts of the Native community, and certainly the Native leadership that were familiar with it.
Thanks.
Okay, thank you. And Cody, do we have Steve back?
I see him in the list. We've invited him to join us back on stage, and hopefully he'll be able to. Looks like he's accepting, so fingers crossed.
Okay.
Aha,
There
here
he
we
is.
are.
Okay, and I will mute myself and go off video.
And does that sound
Here
okay, Steve?
we've got Steve, I guess. Yeah, and next is Steve, and it is his talk is Competing Visions of Tribal Sovereignty in Alaska. And he is going, this paper reviews the history of tribal sovereignty movement in Alaska and some of its consequences for the tribes and for the state. And I'm going to hand it over to you, Steve, and I am going to mute myself and go end the video itself. So can you
Thank
hear
you.
me, Steve?
I can hear you fine. Thank you, Judith. Okay. Y'all can hear me?
Yes.
Okay. All right, perfect. I really appreciate Will's paper. And of course, the quote at the end, thank you so very much. I think this is a really important message that Will has communicated. I think I strongly think that we need to appreciate the context from which the settler mentality came and the long, long, long tradition of property rights and sovereignty that settler point of view represented. It has, of course, no currency now because the situation has begun to rectify itself in terms of the rights and dignity and legitimacy of indigenous people. But to understand the intention of the settler mentality, I think, is very, very important. And I think Will has addressed that really just in a fine way. My paper, I've been thinking about tribal sovereignty in Alaska and the foundation of it for quite a long time. And this paper addresses that. On July 28th this year, Governor Mike Dunleavy signed legislation in which the state of Alaska formally confirmed a government-to-government relationship with the 229 federally recognized Native tribes in the state. This action came pursuant to the enactment of HB 123 by the Alaska legislature. AFN President Julie Kitka celebrated the event with a statement that, and I quote, "We have strengthened our tribal governments and have initiated multiple efforts to continue our path to self-determination and self-governance. The formal recognition through this legislation is an historic step for us to have a successful relationship with the state." End quote. There is a question about the legitimacy of tribal sovereignty in Alaska. Article 1, Section 8 of the U.S. Constitution, the Commerce Clause, states that Congress shall have the power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. This clause is the basis of congressional authority over Native American entities. It's been taken to mean that only Congress can formally recognize tribes, and with that recognition, their inherent sovereignty. Recognition has been taken to mean that the tribe always existed before contact and that it was self-governing. Sovereignty is the power and the authority of self-governance. In 1988, the Alaska Supreme Court, in a case involving the native village of Stevens, ruled that, consistent with U.S. congressional history, there were no formally recognized tribes in Alaska, and that Congress never intended there should be any. On January 11, 1993, however, the U.S. Department of Interior issued an opinion that tribes do exist in Alaska, but Angsa lands don't qualify as Indian country. The legal opinion was titled governmental jurisdiction of Alaska, native villages, overland, and non-members, and it's known as the Santonetti Opinion. Subsequently, on October 21, 1993, Interior Assistant Secretary Ada Deer published a list of American tribes eligible for services from the department. The list included all tribes listed in the Alaska Native Claims Settlement Act of 1971, 227 tribes, mostly village entities. Explication accompanying the list stated that all tribes on the list have, quote, all the immunities and privileges available to other federally acknowledged Indian tribes by virtue of their government-to-government relationship with the United States, as well as the responsibilities, powers, limitations, and obligations of such tribes, end quote. And subsequent to that action, in 1994, Congress passed a federally recognized tribes list. It duplicated the Interior Department list. The act directed that the list be published annually, and that only by an act of Congress, a decision of a federal court, or a lengthy Interior Department process could a tribe be stricken from the list. In the years since, tribal governments in Alaska have availed themselves of grants and services provided by the Interior Department and other agencies of the federal government. The 1994 Congressional Act may, however, be a thin reed upon which to hang the claim of native sovereignty for Alaska tribes. Does it constitute formal congressional recognition of Alaska tribes? That question has not yet been tested before the U.S. Supreme Court. It could be. Native sovereignty is quite popular among Alaska Native organizations and spokespersons at the moment, but the extent of tribal sovereignty in Alaska is unclear. Not all Alaska leaders and analysts fully accept and support the concept. At present, State of Alaska and Alaska Native tribal courts have concurrent jurisdiction over a variety of issues, including child adoption, child protection, domestic violence, marriages, divorces, and probate. Concurrent jurisdiction means that whichever court first hears a case assumes the jurisdiction. Tribal courts were established in many villages pursuant to the passage of the federally recognized Tribes Act, which, among other things, applied the Indian Child Welfare Act of 1978 to Alaska tribes. That act sets out guidelines state courts must follow in cases involving Native children. The University of Alaska Fairbanks Department of Tribal Sovereignty has a trove of very useful information on Native sovereignty in Alaska, including a list of court cases dealing with the subject. I would urge anyone who's interested in the whole question and issue of tribal sovereignty to consult that website, the University of Alaska Fairbanks Department of Tribal Sovereignty. One of the more important cases that the department lists was John versus Baker at the Alaska Supreme Court in 1999. The court found that tribal membership is the basis for tribal jurisdiction, and that the state and tribal courts have jurisdiction over personal relations of tribal members throughout the state, not just, as some had claimed, in Indian country, of which there is very little in Alaska. John v. Baker is a bit of a turning point in the story of Native sovereignty in Alaska. The state had long opposed claims of Native sovereignty, arguing that it would negate or occlude state independence, and at least could impinge on the rights of non-natives. In 1990, before leaving office, Governor Steve Cooper issued an executive order confirming that tribes in Alaska have the power to regulate their membership, manage their internal affairs, and execute such powers delegated to them by federal legislation, such as the Child Welfare Act. Upon assuming office after Cooper, though, Governor Walter Hickel rescinded Cooper's executive order. As a candidate for governor in 1994, following Hickel, Tony Knowles declared that he would address the issue and, once elected, issued a new executive order recognizing the existence of tribes in Alaska in concert with the federally recognized Tribes Act, and announced an agreement to begin a process of a government-to-government relationship between the states and the tribes. John V. Baker was decided in 1999 and gave support to Governor Knowles' position, he was still governor at the time, that Alaska Native tribes had an internal sovereignty that the state should and could acknowledge. Governor Frank Murkowski, who succeeded Knowles in 2002, ignored John V. Baker, and it issued through his attorney general an opinion that tribal courts could not hear children's or any other cases. This left the question of tribal court sovereignty confused and contentious. Governor Palin and Governor Parnell followed Governor Murkowski's lead. By that time, the Alaska Supreme Court had already further confused matters. In 1999, the Alaska Supreme Court reversed its 1988 decision, instead finding that Native tribes had always existed in Alaska, not what they said in 1988, that there'd never been and shouldn't be, and that those tribes have inherent sovereignty. 2 years later, in 2001, U.S. Senator Ted Stevens, State Senate President Rick Halford, and House Speaker Brian Porter wrote to the Department of Interior urging it to revisit the decision to include 227 Alaska Native tribes on the list of federally recognized tribes. The department declined to do so. 20 years later, the Alaska legislature also reversed its stance and passed HB 123. In 2017, Governor Bill Walker reopened the question, and the Alaska legislature passed the Alaska Child Welfare Compact, which recognized the sovereign authority of Native tribes to protect their children. This compact was confirmed in the action of the legislature this year in its passage of HB 123, along with a much broader range of recognized tribal authority. Attorney and historian Don Mitchell has recently published a history of tribal sovereignty in Alaska. Mitchell has been recognized for the quality and usefulness of his thoroughly researched 2 books on Alaska Native land claims history. Earning his law degree at Hastings Law at the University of California in 1972, Mitchell worked for Alaska Legal Services from 1974 to 1977, first in Bethel, then in Anchorage. In 1978, he was hired by the Alaska Federation of Natives as their Washington, D.C. counsel. In 1981, he became general counsel and vice president of the Alaska Federation of Natives. Then, from 1984 to 1993, he worked as the principal outside counsel for AFN, deciding in 1993 to terminate his AFN work. That was the year, of course, that Assistant Secretary Ada Deer published the list of federally recognized tribes that included the 227 tribes in Alaska. That number, by the way, is now increased to 229 as 2 additional tribal entities have been recognized on the list. From the early 1980s, Mitchell has been a critic of tribal sovereignty in Alaska, not because he disagrees with the principle that native villagers should have the power of self-government, though he has serious reservations about the usefulness and wisdom of such self-government in many situations, but because he distrusts the legal and judicial foundation on which tribal sovereignty is based. Mitchell believes in the rule of law. He believes that if judges can change the law at their whim, or if the executive branch of the government can simply declare the law to be what it wants it to be, then the law has no force and its legitimacy is suspect. He believes that Assistant Secretary Ada Deer's executive action in 1993 of adding 227 native villages in Alaska as tribes to the list of American Indian tribes eligible for Indian Department services was arbitrary, contrary to law, and ultimately fraught with danger for those tribal entities when their legitimacy as congressionally formally recognized tribes may be challenged at the U.S. Supreme Court. His challenge to that legitimacy, that legal legitimacy, has made him a pariah among Alaska Native groups and non-Native groups and individuals who embrace Native sovereignty. It has cost him much legal work for which he is eminently qualified, and has led many to distrust his scholarly work, which is thoroughly researched and insightful, as manifest in his published works on Alaska Native claims history and on Indian gaming in the U.S. In his latest book, Tribal Sovereignty in Alaska, How It Happened, What It Means, he delineates the history of the tribal sovereignty movement and the role of attorneys for the Native American Rights Fund, a nonprofit organization that provides legal assistance to Indian groups and individuals throughout the U.S. NARF has played a major role in the legal, judicial, and political history of the Native sovereignty movement in Alaska. Mitchell contains that Native sovereignty would not have made the strides it has without the involvement of the NARF attorneys, who include Heather Kendall Miller and Lloyd Miller and Robert Anderson, who is now at work in the Solicitor's Office of the U.S. Department of the Interior. How effective Native sovereignty in Alaska may be in addressing the crushing challenges facing Alaska Native villagers remains to be seen. Teen suicide, chronic alcoholism, spousal and child abuse, substandard school performance are major dysfunctions not easily treated or solved under any form of government. Self-governance may help villagers to focus on these and other issues. Meanwhile, concurrent jurisdiction with the state should help ease tensions over such matters as child custody, marriages and divorces, and other issues which I mentioned. But there are jurisdictional tensions in law enforcement especially, that sometimes become dangerous. Mitchell, in his book, describes several in which armed villagers claiming sovereignty confronted state troopers attempting to enforce law and policy. In future, hopefully, jurisdictional lines can be clarified with the government-to-government relationship and such dangers obviated, one would hope. Tribal sovereignty in Alaska today is an apparent fact. How it became so, how it arose out of conflicting visions of the legitimacy and efficacy is a story worth knowing. Mitchell's book will be of inestimable value to future scholars and readers who seek to understand the origins, basis, and evolution of Native sovereignty in Alaska. I think that this is as clear an example of conflicting visions of Alaska history as one might find, and I hope that this paper will encourage listeners and readers to school themselves as best they can on this, I think, very significant issue. Thank you.
Thank you, Steve. Very insightful. It's both our speakers have given us lots to think about, and we do now have time. We have about 30 minutes for discussion and questions. And I do see a question from before, and then I will ask for additional questions in just a minute. Let me get my timer. I don't want it to buzz right in the middle of something. But it looks like we have a question in Ask a Question. So does everybody see that, I wonder?
Can you read it?
Yeah. Will, this is to Will. What do you anticipate as possible solutions to our dual system of managing fish and game in Alaska? And this is from Russ, and I will.
It's an easy one.
An easy question. Wow. I still am hopeful that the state and the federal government will find a way to work out this dual management system, and I think maybe what's needed is a ballot initiative, because I think that the citizens of the state ought to re-examine this issue to see if a rural subsistence preference is something that they want. And I think it would also provide an opportunity to infuse some education in terms of the different lifestyles that are represented throughout Alaska in rural and in urban areas, as well as demonstrating the strong needs of urban hunters, some of whom depend upon the resources as well. So it's a debate that ought to be held publicly, and a ballot initiative, I would suggest it would be the best option.
Okay, thank you, Will.
You want to give Steve a chance to respond?
Yes.
Steve, do you want to speak up on that one?
Well, I absolutely agree with you, Will. I think that a ballot initiative is really the cleanest way to address this. The legislature, of course, had ample opportunity to deal with it from 1980 to 1999, when the federal government said, okay, 20 years is enough. We're going to step in and guarantee a rural preference on federal land. I would like to be optimistic that if this were brought up to the legislature again now, 20 more years later, that that the state might be willing to recognize what I consider to be the wisdom of the federal government guaranteeing a rural preference for subsistence harvest on federal land. I think that the federal state councils, regional councils, have shamed the state because although not everything is perfect, they seem to be working reasonably well. They take testimony from regional users quarterly. Those are available online for anybody who wants to look at them, and they work out solutions. As I say, it's not always perfect, but they have, I think, facilitated particularly hunting and in some cases the fishery to the satisfaction, general satisfaction of the regional users, where the state for 20 years and now 20 more years of silence has refused to address the issue substantively. So I would like to think that maybe the legislature could do it now, but I think a ballot initiative would force their hand. And so I agree with you, Will. I think probably the ballot initiative is the cleanest way to approach this.
Thank you, Steve. David, do you have a question for
Sure,
us?
I have a question of Steve. My general impression is that federal courts have taken a fairly progressive view of issues involving U.S. indigenous groups, particularly Alaska Natives. Do you think that will change dramatically with the overwhelmingly conservative new U.S. Supreme Court? And are you aware of any cases coming down the pike that could directly affect Alaska?
I'm not sure how we should interpret the Venati decision, which definitely went against Alaska Native sovereignty and against the whole question of legitimizing Indian country in Alaska. My impression is that the Supreme Court is not any more favorable today than it was when it decided Venati. If anything, less favorable, given the composition of the court now. And there are a couple of issues. Eklutna would love to have a casino, but the courts have not been friendly to that, to the Eklutna attempt so far. That's still pending at the moment. Eklutna is still attempting to get the authority that it would need for that. I don't know of any immediate cases that are pending before the court or about to come down the pike. The NARF attorneys and others who are familiar with the law in ways that I am not, I think would be the right people to ask. But I'm not optimistic that the federal courts, at least once you get beyond the Alaska District Court, are any more favorably disposed toward sovereignty in Alaska than the Supreme Court was at Venati.
Thank you, Steve. And I'm going to turn it over to Will to address that question too.
I would raise it more in the way of a question, but to David, the Supreme Court ruling in the Sturgeon case may indicate a certain direction of the new court as it relates to powers of the federal government in terms of navigable waters, and in turn, activities on those waters, such as fishing. So I think we should watch that very closely as to how that plays out, even though what has been publicly said so far is that sturgeon would not affect native activities on federal land.
Yeah, I think that's a good point, Will. Thank you. And Kagan was very insistent in the majority opinion that the sturgeon decision would not affect Katie John or native fishing rights.
Okay. And we do have a comment in the chat that a ballot initiative, which both of you have talked about, would have to include a constitutional amendment to make a rural priority possible under the Alaska Constitution. Yeah, that would be
true. That's clear from Will's paper. Yeah, absolutely.
Yeah. Okay. Any other questions or comments by the speakers to one another? David?
I'll ask Steve one more. You had mentioned that Senator Stevens joined with, I think it was Halford and Porter, to write a letter to Interior on tribal recognition. Do you know if that was a Don Mitchell ghostwritten letter? It seems to me I recall that he had a hand in that.
Yeah, certainly he had a hand in that. Mitchell tells an interesting story. He and Senator Stevens were driving up the Glen Highway about that same time. This would have been around 2001. and they went by the little road beyond Sutton that goes into Chickaloon Village. And there were a couple of cars parked there, and a couple of Chickaloon villagers armed with sidearms were preventing anyone from turning off into that road without being questioned about what they were doing there. According to Mitchell, now this is all secondhand, of course. According to Mitchell, Stevens went apoplectic over that. So I think that that protest, if you will, if I can call it that, to some of the aspects of sovereignty has been latent, but it's still out there. I definitely think it's very definitely out there. And Mitchell, because of his position at AFN and then his deep research of Native issues in Alaska, was indeed, I think, involved in generating that letter to the secretary, and subsequent letters, all of which have not interfered to date with the Interior Department's recognition of the 229 tribes in Alaska and their inherent sovereignty.
Okay, do we have any other comments or questions from to our speakers? Okay, I have a question or something that has come up with the list of villages versus sort of ethnographic and linguistic groupings of Alaska natives, and the use of the village list of villages versus another kind of look at or approach to tribes is on kind of a linguistic or ethnographic connection between them, and is that another way of looking at groupings of tribes that kind of fit lower 48 models, or just another way of looking at Alaska Native groupings? Will, do you want to address that?
Yeah. I'll start and Steve can hop in. Yeah, it always struck me as a little strange, the use of the word tribe, because from an anthropological standpoint, tribe has a somewhat different meaning, in that tribe encompasses a wider range of clans and communities that shared certain common traits and certain systems of justice and certain administration. So, following what I had talked about earlier in terms of how I define cultural, in terms of social, legal, economic factors, those would influence how and language is how we might define a tribal group as opposed to a small community. Now, historically, of course, the consolidation into small communities with the establishment of schools and churches and services has kind of contracted the settlement pattern. So settlement pattern has changed, but the use of the word tribe is, at least anthropologically, inappropriate in terms of that application. But I suppose if you are the solicitor, you're looking at the easiest way to designate certain rights to Alaska Natives, and the fact that people are living in villages may be the simplest solution, even though historically it strikes us as a bit odd. So maybe Steve has more on that.
Oh no, that's I have nothing to add to that, except that just a little bit of history. In 1934, when William Paul was working with Felix Cohen and the Indian office back in DC, they were tearing their hair out over how to get the Wheeler-Howard Act, the 1934 Indian Reorganization Act, to apply to Alaska, since the question of tribes in Alaska was still very much up in the air, if at all. I mean, the general feeling at that time was that Congress had not and was not about to recognize any tribes in Alaska. So they had to come up with some solution, as you well know. And the solution, I don't remember the exact language, but it was any group with a common association or something like that would qualify for an IRA constitution. And I think you're quite right, Will. Just as a practical matter, the Interior Department and other agencies of the government have to find some way to confer these rights. And tribe, I think, is the easiest way for them to do it.
Yeah, and of course, historically, we recognize that we don't have any treaties in Alaska, and as opposed to the continental United States, where groups of Native people in the early years were confronted by the federal government, and treaties were established which laid out quite clearly extent of territory, and so it came in 1936 with the Indian Reorganization Act in Alaska. This came at a much later period in the history.
Yeah.
Okay, and let's see, we've got a comment in the chat from Jim. Can't see that.
Jim
Mandance. Tiger Birch argued that what the U.S. and Alaska call tribes actually functioned as nations, as that term is commonly understood.
Yeah.
Okay. Okay. Any other comments or questions? Wait, it looks like we've got one here. Let me see.
Let me just reinforce what Jim was saying and what Tiger was saying there, and that is that in the Inupiaq country, there were very definite territorial boundaries that Tiger Birch documented, and he saw these as very much like functions much like nations. Had a paper, I think, to the Historical Society
in the journal.
It's in the journal, talking about that concept. So that'd be worth following up, and I'll make a note to myself to look at that again.
Okay.
Or was it his book?
Okay. Well, we've got another question here in the questions, and I'll take it as, and it is from Russ Vanderloop. Thank you both. What do you think about the problem of future health of fish and wildlife populations in Alaska that do not necessarily heed borders between state and federal lands where different regulations apply? Do you foresee management by a single entity across borders as a possibility, given the systems we've enacted across the checkerboard of land ownership in Alaska? And Will, do you want to start, and then we'll go to Steve?
Yeah, I think there are people more qualified to talk about how the dual management system has actually worked out on the ground. I think there's been some level of cooperation between federal and state managers as to managing the actual resource itself. But the conflict at the personal level, I think, exists. And that is that do you have your rights in certain areas, but not in other areas. And so if you're hunting or you're fishing, your movements are, if you want to stay within the law, your movements are predetermined by those boundaries.
Steve, we'll turn it over to you.
Yeah, thank you. I'm optimistic, given the reasonable success of the federal, state, regional councils in handling subsistence harvest. I would like here to take refuge in the old saw that historians are a hell of a lot better at speculating about the past than they are about the future. But I'm, as I say, I'm reasonably optimistic about that. I would speculate that if there were a single entity that had jurisdiction over both state and federal land, I think that they would still rely upon the network of the regional councils and the people who involve themselves in those regional councils or something similar. But I was struck recently when reading Seth Kantner's latest book, 1,000 Trails Home, about his life among the caribou, that he reports that he once got a bear permit and actually took a bear. And the bureaucratic haze that he had to negotiate to get the permit, to turn in the ear or whatever he had to turn in, and all that, left him so frustrated that he said in no other hunting excursion that he was ever going to undertake would he deal with the bureaucracy.
Okay. That seems like we've got plenty of bureaucracy all around us all the time. Those of us that worked for the state for 40 years, yeah, can attest to that. We have another comment here. It says, from Sioux Sheriff, our general consideration of tribes at large is not necessarily the anthropological construct when you look at the lower 48 indigenous people either. For example, the Cherokee of Oklahoma, the Eastern Band of North Carolina, etc.
Yeah, fair enough.
And I think the question that we have here is, this is the same one. I have just thoughts on the land kind of ownership and the complications. There's corporate land, village, regional corporation lands, village corporation lands, and tribes. They might have some land in trust, but not necessarily the land base, which might fit into the village or regional corporations. And then just how that ways to get that resolved, or just your thoughts on that. Steve, do you want to go first?
Well, Will might be better to address this than I.
The easy answer is I don't know. I don't.
You had a more eloquent way of saying that than I did.
I don't know how much conflict there is, although the areas of jurisdiction remain pretty vague to me as an outsider looking in and trying to study it. But perhaps people on the ground are able to sort it out easier than I am. You know, for instance, the village of Tanana, people don't have to leave when they're elderly and sick. And I believe that goes to the tribal entity in Tanana. But I think that the tribal entity and the village itself may be, in fact, the same thing, although I can't sort that out at the present time.
Well,
Steve, any thoughts?
We should also remember that there are local jurisdictional tensions sometimes too between the village corporation, the first or second or third class city or borough government, and so forth. So it's a conundrum, and I think it would, Will, I agree with you. I think it really takes people who are on the ground and dealing with it daily to answer that question adequately.
Yeah, and in that particular case I mentioned Tanana, there is a Tanana City Council. So you've got a Tanana City Council, you've got a village council, you've got the regional corporation and the village corporation, and
Right.
somehow the tribal entity.
Yeah, and then you can lay over the sovereignty in
Yeah.
that. And then there's also now with kind of some tribal jurisdiction, tribal lands that BIA is holding in trust tribal lands. And so there are some rights that go with that as well. And as the State Historic Preservation Officer trying to figure out, just sorting out jurisdictions and authorities and consultations. Just another example of just how complex and different Alaska is to the lower 48 when you're dealing with government to government relationships and consultation.
Do you have some examples you could share with us on that? Anything in particular that?
Well, no, I just in
general.
Just in general,
Yeah.
because each place, each kind of undertaking we deal with, each project, looking at those who have interest in it and who's got some authorities or responsibilities in relation to land and authorities to make decisions on that. And also, as part of the services that are granted by the Department of Interior, get involved in that. And so with like the State Historic Preservation Office, that, it's federal law and there's certain responsibilities to represent at the state level, advising federal agencies in the implementation of their laws. Tribes can take over those responsibilities on Indian country and tribal lands. And in Alaska, without the definition of tribal lands, Metlakatla has tribal lands, and the Department of Interior has decided administratively that BIA land held in trust for tribes constitute tribal lands, and so on those lands, the tribes can have jurisdiction, can take at their discretion responsibilities of the State Historic Preservation officers, or offices' responsibilities. And we have one in Alaska that's Cake, and it has the 14 acres of tribe BIA held land on their behalf, where the Cake Cannery is. And so the Cake tribe works as taken on the responsibilities for Section 106 consultation for that 14 acres. So that, but just the land status between all the entities, with the INCSA is complicated up here. And I think then related back to sovereignty, you've got, that sovereignty is often land-based or not necessarily land-based. It's governmental. So you have governmental responsibilities in providing services and other things as a government. And how does that relate to your land base, or does it need a land base?
I hadn't thought of it in terms of historic preservation, but that's a wonderful example that we need to do some more work on.
Indeed.
How many BIA tribal, how many land acres in Alaska and different tribes are impacted by that situation like in Cake?
I think it's becoming more common. I think that is becoming because of that administrative decision by the Park Service and Department of Interior to consider certain tribal rights or land rights of BIA land held in trust for tribes. That comes, there's a whole thing that goes with it. And I don't personally know, I haven't done all that studied. I just know on the historic preservation side, the impacts there, because that's the program that I work with. But, I'm not sure broader and on how it relates to gambling, and as well in that kind of thing. So it's just another question that needs research and case law as well. I think a lot of this is decided through case law and some research. That's just an area that I have questions with, but no answers. So we have a few more minutes. Do we have any other things here? Okay, that was the same one. Okay. There is also pending native allotments for Vietnam era veterans that will be more Alaska lands through the BIA, and that is more individual lands, and that really goes for held in trust for the individuals, which then can go into private land when that trust is good. But that's like, that's going to be huge.
One of the issues with that Veterans Allotment Act is finding suitable land available for veterans to have their allotment of 160 acres or whatever it is. And that's been a problem in some of the more populated areas because there isn't available land that's close to the village or close to the area where the person's from or living.
That's right. Now, we've been working actually through the State Historic Preservation Office, working with BLM as they do select lands that are available and don't have other kinds of restrictions and layers to them.
What's your job on that? Is it to determine historic ties to that land, or what's the?
What we look at is the impacts, the impacts to where historic properties and 14H1 sites are located and identified and known historic properties. What is the impact possible for those selections? And are there some kind of congressionally designated lands that should not be part of that pool? Could be like the Iditarod Trail is a nationally designated historic trail. So you wouldn't necessarily want to have lands available for selection where there would be a right of way, of that trail going through it. And where are the 14H1 sites that the corporations and they had identified? You wouldn't necessarily want that to go into the selections because then it becomes private property. So they're just certain sites that have already been identified for management for preservation.
Just a point for listeners, 14H1 refers to the historic and cemetery site selections under ANCSA.
Yeah. Okay, well, I'd say we're at 12:29, Cody. Any other final words from Steve or Will on this? This has been very interesting conversation.
Well, I'm delighted to have been able to be a part of this, and again, kudos to Will for his superb history of the cultural exchange, if I can call it that. As discussions of this nature go forward, I'm always uncomfortable that we don't have native participants, and I think that would enrich the discussion here substantially. But thank you for the opportunity, and thanks to Cody Carver for sorting out the technical issues. Everything seems to be working fine right now. Thank you all.
Thank you, Steve.
And thank you, Cody. Thank you, the Historical Society. And this brings to a conclusion.
And thank you, Judy.
Yeah.
Thank you, Judy.
Conflicting Visions in Alaska History session. Thank you.